So first off, I am very happy to see all of you. I think your last class before the storm was me. That sounds right. 12 something days ago. So I'm happy to see everyone here. I hope you are all safe. I am taking attendance, but I'm not counting it. The reason why I'm doing this is because the dean is very much concerned about his students. Dean Gooder is a former admiral of a ship. He sees all of you like his sailors and cadets, and he wants to know where all of his people are. So one of the only ways we can actually check where people are is by taking attendance. So please check in. If you're not here, you're watching at home, I will excuse you, but we want to know where you are. Also, if anyone in this classroom or watching at home online has any issues that the school can help with, talk to me, talk to the dean. We want to help you. We want to be as accommodating as possible. This is a significant event that befell our city, and the school is here for you. So we'll help with whatever we can. We can't help with traffic. It took me twice as long as usual to get to school today, which I think is probably very far from the course. Don't worry about makeups now. I'll schedule those at some point in the future. Do you all have the same schedule? No. Okay. Then we'll either have to do a night or weekend class. There's no way around it. Attendance will not be required. I'll be recording them so you can watch them at your leisure, but it's the only way to make up time. Occasionally when I have first semester students who have the same schedule, I can like find a block where they're all free, but if one student has a class conflict, I can't. So either something at 5 or 6 or on a weekend, but everything will be recorded. So it can't be, which is why weekend is probably even more likely. I'll do the best I can.
Friday classes.
Fridays, you have class on Fridays, none of you?
But you said attendance is I can watch live.
Watch it live. Well, if I'll tell you what, I've done this before, and someone always emails me at the class, I have something on Friday. So if anyone has any objection to Friday classes, if you're here watching online, you can email me later or come to my office. My rule is I don't schedule something if one person has a class conflict. Work conflict I can be a little bit more forgiving for, but I can't schedule my classes. Some of you always do that trial academy thing. Anyone ever do that one where you miss 3 classes to get credit? Do that? The school offers this thing where they let you be a jury, right, for the mock trial tournament. And basically they're giving you class credit to skip my class, which always boggles my mind every year. Don't do that. Anyway. It annoys professors, but it's probably better for you. Is there anything anyone wants to ask before we get into the lesson about the Constitution, about flooding, about damage? I don't know. This is more relevant in property, I suppose. But anything on your mind before I start? All right. So what I want to do today is bring you back to the mindset of being a law student. You've had a 12-day break, longer than spring break or anything else you'll ever have in law school. I want to bring you back in. And the way I want to do that is by recapping our last class, which was, I think, 12 days ago, if I can count, in which we discussed the enumerated powers. And you'll recall we covered a number of cases involving 2 provisions of the Constitution, the Commerce Clause and the Necessary and Proper Clause. And these clauses work together in a funny way, right? If Congress is in fact regulating economic activity, they can rely on the Commerce Clause. But if Congress is regulating something beyond economic activity, they have to defer to the Necessary and Proper Clause. This was seen first all the way back with Justice Marshall, McCulloch v. Maryland, where the Chief Justice said that a Bank of the United States is not itself commerce, but as a necessary and proper means to regulate commerce, the bank is an appropriate method. So you have to think of the Necessary and Proper Clause, this elastic clause, as giving Congress additional powers to achieve what is enumerated. But the way the court has read the Necessary and Proper Clause shifted over time. We saw Justice Marshall in McCulloch v. Maryland and Justice Story in Prigg v. Pennsylvania read the Necessary and Proper Clause very broadly. And then we saw Chief Justice Chase, in some cases from the 1860s, read the necessary and proper clause narrowly, such that Congress couldn't require businesses to accept this paper money, this legal tender, right? Congress couldn't regulate oil, remember this, the lighting oil within a given state. And they kept building upon this. During the Progressive era, the court tried to maintain these distinctions between local commerce and national commerce. They drew these distinctions between indirect and direct effects on commerce. But all of that line drawing more or less came to an end in 1936 and 1937, when the court, during the New Deal, shifted its case law on the Commerce Clause. NLRB versus Jones and Laughlin Steel was the key case. And it overturned all these precedents that drew distinctions between direct and indirect effects on commerce, local and national. And they applied what we call the rational basis test to the Commerce Clause. That is, so long as Congress has some legitimate reason why they think this is a regulation of commerce, that's good enough for the courts. Courts will no longer distinguish between manufacturing and trade and agriculture, it's all together. And then we get to Wickard v. Filburn, which I'll come back to in a minute, which was the furthest reaching opinion yet about the court's powers, where they allow Congress to regulate wheat grown on a farm that was never destined for the interstate market. I think one of you was a farmer, told me afterwards that maybe it was for his own farm. I'll stand corrected. Maybe he's right. I don't know. And that was the law, right? If you went to law school in the 1940s or 1950s or 1960s or 1970s or 1980s, and your professor is standing up here who have taught you that the Commerce Clause means the president can do whatever, Congress can do whatever it wants. That so long as Congress finds some basis to regulate something in interstate commerce, they can do it. That would not change until the cases we're covering today, which is roughly known as the Rehnquist Court, under the stewardship of Chief Justice William H. Rehnquist. And the Rehnquist Court, which was consisting primarily of appointees by Presidents Reagan and H.W. Bush, invigorated federalism. And one of the areas it did so was on the Commerce Clause and the Spending Clause, which we will talk about in Dole. But what's important, I think, for you all to recognize is that the Rehnquist Court never actually overturned the New Deal cases. The Rehnquist Court never overturned Wickard. They never overturned Jones and Laughlin Steel. They didn't overturn these cases. Rather, they found ways of distinguishing these cases. Now, the dissent from Justices Breyer and Souter, they don't believe this, right? They don't buy these sorts of distinctions between this and that. They say that these cases are basically ignoring the New Deal decisions. And we can talk about that later today. But where I want to start our discussion is to repeat a frame of how the court approaches these cases with respect to the necessary and proper clause and the Commerce Clause. So here's your question for you to consider. It's on the board. I'll put a polling session on. Okay, the question is this. In Wickard v. Filburn, the Supreme Court upheld regulations under the Agricultural Adjustment Act solely on the basis of the Commerce Clause. Wickard v. Filburn, the Supreme Court upheld the regulations under the Agricultural Adjustment Act solely on the basis of the Commerce Clause. That's your question. All right. Give another few seconds. All right. Who remembers where we were last week? We finished.
You remember? Are you like?
Are you next?
I think it's me. I think I'm up.
Were you worried all week that I'd call on you? Was that your fear?
No.
Good. I had a guy shoot. That's like, yeah, I knew you were gonna call me all week, so I was waiting for it. All right, Boone, you're up.
Okay.
What did you put? True or false?
I put false.
Okay, why'd you put false?
Because I don't really remember that well, but I think they probably used like necessary and proper or something else.
Alright, Jason, I think it's that, what'd you put? False. Okay, why'd you put false?
I'm not sure.
Jackson, you next, I think? Okay, Jackson, what'd you put?
I also put false for the same reason. I couldn't remember if they used the necessary and proper clause in conjunction with the commerce clause to stretch the.
Okay, did anyone put true? Oh, Brittany, what'd you put?
Put true.
Okay, you're next, good. Why'd you put true?
It's fuzzy, but
Yeah,
I
it's a long
remember-
time ago, I know.
yeah, I remember us talking about the commerce clause. Like you said, I remember them talking about something else, but I thought it fell back on the commerce clause.
So, Brittany, let's walk through this. What was actually being regulated in Wickard? What was actually the item being regulated? I'll cut slack today.
Okay.
Kelsey?
Wheat.
Wheat. Okay, good. And specifically, what about wheat was being regulated?
The amount that farmers could grow was.
Okay. So at issue in this case was the growing of wheat, right? How would you, Kelsey, stick with you for a second. How would you describe the growing of wheat? What sort of activity is that?
Agricultural.
Yeah, but in general, how does that fit into our society? What kind of activity would you describe that as?
Commerce.
Good. What's a synonym for commerce that the courts have used?
Production.
It was in Lopez. They used this word over and over again. I don't see a name tag, but Mark.
Fungible commodity?
It is a fungible commodity, but how would you describe the activity? Give me an adjective.
The trading?
An adjective for activity. How would you describe it? Crystal?
Is it interstate?
No. Close. You don't know where I'm thinking of?
Economic.
Economic. Thank you. Okay? That's the exact word I'm looking for. Thank you. It took a couple people, but eventually got it, right? The growing of the wheat in Wickard was an economic activity. Right? The growing of the wheat itself was an economic activity. Everyone agrees with that. I don't think I agree with it, but that's at least what the court held, right? I think actually trading wheat's economic, merely growing it's not, but I'll leave that aside for a moment. The growing of the wheat is an economic activity. Now, Martin, go to you for a second. Was this economic activity solely within one state, or is it across different states?
Solely within one state.
Okay, so was this economic activity intrastate or interstate?
Intrastate.
Okay, very good. So we had here, Martin's correct, an intrastate economic activity. Everyone agree with me, right? The actual growing of the wheat, right? Unless you have a farm on the border, right? The growing of the wheat itself has to be an intrastate economic activity. Okay? Everyone with me? Now, Bahara, is that the end of the court's analysis, though? Is Congress unable to regulate intrastate economic activity? Does Congress have the power to regulate that?
I think it said that it can also regulate interstate commerce if it has a substantial effect on commerce.
Ah, what's the substantial effect?
The test they did.
What's that test? You're exactly right. Congress can regulate intrastate economic activity when blank, fill in the blank.
When it has a substantial effect
On?
interstate.
Yes,
commerce.
bingo, perfect, 100%, exactly, right? Congress can regulate an interstate economic activity when it has a substantial effect on interstate commerce. Okay, and I want to repeat that sentence one more time. Okay? Congress can regulate an intrastate economic activity when it has substantial effect in interstate commerce. Everyone agrees with that, right? So let's go back to the true-false question asked. Was Wickard a necessary and proper case or a commerce case?
Well, I guess it would be just a commerce case
Yeah.
because it,
That's right, A is the answer. Right? The answer is A. Look at that. Okay. So the answer is A. And the reason why is they don't need to go to necessary and proper. Because the economic activity itself, even though it's intrastate, has a substantial effect in interstate commerce, there's no need to go to necessary and proper. So long as you have an economic activity that has a substantial effect. Jackson?
So substantial effect test is part of the
Yes.
commerce clause, not the necessary.
Yes. Yes. Exactly. This is a part that most people never actually quite grasp. I think now you get it, right? The reason why McCulloch v. Maryland needed to go to the necessary and proper clause is because running a bank was not interstate commerce. But here in Wickard, they say growing wheat is an economic activity. I think that's wrong. I don't think growing wheat is, I think trading wheat would be. But the court takes this definition. So if agriculture, right, merely growing something is an economic activity, then we know that that economic activity has a substantial effect on interstate commerce. How do we know that? Emily, how does just poor Mr. Wickard by himself, how does his activity alone have a substantial effect? He's just one guy with a couple bushels of wheat.
Well, they talk about the aggregation principle.
Ah, beautiful, yes. What's the aggregation principle?
It's basically the idea that one person alone might not have a substantial effect, but there might be copycats or other people who think they can get away with growing their own wheat, and so it will have an effect on the total national market.
Yes. Yes. Exactly right. Even though Filburn by himself, his activity alone won't have any effect on the market. But to get to substantial, you can aggregate. You can add together all the farmer Filburns in the country with their locally grown wheat. And if all of them do that, then you get added up in the aggregate substantial effect. But again, does Congress need to make findings to that specific fact? The Wickard court seems to suggest not. They say Congress, if they can conceive of how all these farmers together can affect interstate commerce, that's enough. Oh, stop this. It's still running. Okay? Right? So when you're answering these sorts of questions for my exam or anywhere else, I think you'll think about these anywhere else, but in theory, right? Pay very close attention to a clause you're using. I can tell you the number one error in these sorts of questions on the exam is going to be, you're giving me necessary and proper when it's not applicable. Or you're giving me commerce where it's really necessary and proper case. You have to know the difference. I'm not going to tell you which is which, right? So you can give me a perfect answer under McCulloch and necessary and proper, but if this is a commerce clause case, you're wrong. So get it straight. Okay? Are there any questions now before we get started? All right. Oh, please go ahead.
how, if it's, what limits substantial effect then?
Ah! Isn't that Justice Thomas's question, right? This is Justice Thomas's question in the Lopez case and Morrison. If you can aggregate total local conduct and make it into a national issue, is there any limit on Congress's power? And that's actually a great question, a great way to kick off our discussion for today. The single fact in all the cases, Lopez, Morrison, and Raich, and we're going out of order today. We'll do Dole last. But I want to do Lopez first. You can start flipping now. We'll do Lopez first, then we'll come back to Dole at the end. But the single question for Lopez, Morrison, and Raich is this: what is the limiting principle? What is a limiting principle? If they can regulate this, what can't they regulate? Indeed, this was the defining issue of the Obamacare litigation. If Congress can make you buy health care, what can't they do? If Congress can regulate a gun in a school zone, what can't they do? If Congress can regulate domestic violence, what can't they do? And at each juncture, we have to be candid at both sides of the debate. The conservative justice said, well, this goes too far. Look, the dissent, they can't identify any limiting principle, so they're wrong. And the dissent says, well, we thought this was settled by the New Deal court in the 1930s and 40s. They're both right. It's possible to reconcile Lopez and Morrison with the Wickard court, but it's an odd fit. Okay? It's an odd fit. They do it. I think it's actually a principal distinction, but it's not keeping with the spirit of the New Deal court. The spirit of the New Deal court is basically rational basis review. What I think the Rehnquist court says, okay, we went this far in Wickard, we're not going any further. This far further, we reach our outer bounds, we're not going any further. Okay. So let's look at Lopez for a minute. Close this. Lopez. And we'll come back to Dole later, I promise. So, United States versus Lopez took place at Edison High School in San Antonio. Did we go there by chance? Or know where it is? Every year I've been one person sometimes does it. Anyway, this is actually a picture of Edison High School in San Antonio. And years ago, I can't remember who sent it to me, but some guy, I had a blog post, what I call Constitutional Faces. He sent me a picture of Lopez's high school yearbook picture. It's really blurry. So this is him, the one in the middle. And you can see on the next line it says, Alfonso Lopez. Here he is playing soccer. Rushing down the field, Alfonso Lopez warms up before the game, I think that's what it says. Yeah, I mean, they sent me these really blurry pictures, which I can't use, in any meaningful publication. But I have, so that's what he looked like. And he brought a firearm to school. Now, Texas law, even at the time, prohibited you from carrying a firearm in school unless you had the proper permits. He was originally arrested by the local San Antonio police and charged with a state offense, but then they turned him over to the feds. The federal prosecutors want to charge him with this brand new Gun-Free School Zone Act. This brand new federal law. Now, the states had all the power they needed to prosecute the guy, right? Shimon, why do you think the state prosecutors were all too happy to turn this guy over to the feds? Actually, he was a kid, he wasn't even a major yet. I think he was like 17. Why? Maybe he was just 18. He was just 18. Why were they so happy to turn Lopez's case over to the feds? Say a guess. You don't have to know.
I really don't know. Maybe.
Why do you think the
maybe
state?
a longer conviction time for him?
Who does all the work?
The federal government.
Yeah.
Yeah.
So this is a very common practice of our criminal justice system, where certain serious offenses, state prosecutors are all too happy to hand the case over to the federal government. The reason why are many. Shivan said longer sentences, that's generally correct. But the more important question, who's paying for it, right? When someone's sitting in a county jail, the county's paying for it. When someone's sitting in a federal prison, the feds pay for it. They pay for the prosecution, they pay for the appeals, they pay for the lawyer. So the state's all too happy to give away, oh yeah, you can take this case, right? So they handed this case over to the federal government, and the U.S. Attorney brought a federal indictment under this new Gun-Free School Zone Act. Now, Brittany, you're the lawyer for Mr. Lopez, and he actually had a federal public defender. So these people are not particularly well paid. They don't get lots of credit, but they do a very important role in our society. Now, a lot of students ask me, Josh, I want to be a constitutional lawyer. How do I do that? Well, I mean, you can go join the ACLU, and you can go join NARAL, and go join Beckett Fund, and whatever else you want to do. That's fine. But if you actually want to practice constitutional law, the but the most direct way is by criminal defense or prosecution. It involves the 4th, 5th, and 6th Amendments, these criminal procedure amendments, but it also involves challenges to federal power. Now, I always use this example as a reason why students should always pay attention in law school. If you were Alfonso Lopez's lawyer, and you were, 1995, 96, whatever year it was, and you had gone to law school, say in the 80s, your professor told you, the Commerce Clause has no limits. Congress can do whatever it wants. That's what your professor would have told you. I'm sure Lopez's lawyer was told that. I actually emailed him. He was a federal defender in San Antonio. He never replied. I have no idea if he's still even employed, but I emailed him maybe 7 years ago. But, Brittany, Lopez's lawyer obviously thought a little bit different, right? So, while most lawyers would have just taken a plea bargain, right, and let the case go away, and his client would probably gotten maybe a year or two in jail, first time offense. 18 years old is a pretty young kid. What did Lopez's lawyer do instead of just pleading the guy out, which is what I think most lawyers would have done in a heartbeat?
They claimed that they exceeded the powers of the Commerce Clause.
Lopez's lawyers claimed that he exceeded the powers of the Commerce Clause. Now, Brittany, what do you think the attorney's colleagues at the Federal Defender's Office said to him when he was following these motions? What do you think they told him?
I'm sure they laughed at him and said that there was no way it was going to
Yeah.
pass the first round.
Yeah. I think you're exactly right. You can imagine, and I'm dwelling on this point for a minute because I want you all to realize you will be lawyers in 2 or 3 years. And if you guys do criminal defense, which is, again, important work, doesn't pay a lot, but it's important, you're going to have people's lives in your hands. And if you decide, oh, screw it, I'm going to give this guy a plea bargain and move on to my next case, or, all right, let me go write a 20-page brief arguing about the Commerce Clause and explaining why the New Deal is different from this, right? So this was a decision of a lawyer, an actual person, probably not much older than all of you, who made this decision. And he said, look, I'm not challenging the New Deal here, right? I'm not challenging Wickard. But this case is different than Wickard. That's what you do in legal writing, right? You distinguish precedents. And Brittany, finish it up. Why is this case, in Lopez's mind, or his lawyer's mind, different than Wickard?
Because him having a gun at school doesn't substantially affect interstate.
Well, no. Go back to our test. Before you get to substantial effects, what's your first question?
Is it interstate, or is it economic activity in law? And him possessing.
So the first question, very good. The first question, again, I wrote this sentence out here like this quite deliberately, right? The first question for you to consider, right? Okay. The first question for you to consider, is this an economic activity? Because if we do not have an economic activity, the Commerce Clause is inapplicable. That's why this question with Wickard is framed the way it is. You only use this test if you have an economic activity. If it's not an economic activity, Kelly, what clause do you have to go on to? Yes. Exactly right. This is McCullough v. Maryland. If you have an economic activity, you stay with the Commerce Clause. If it's a non-economic activity, you go on to the Necessary and Proper Clause. Everyone see that? Everyone understand the relationship? So you have to ask yourself, is possessing a gun by itself in a school zone, Kelly, an economic activity? What does the court say here?
The court says it is.
Just possessing a gun? Just the possession. Possession by itself of the gun is not an economic activity. Everyone see that? The mere possession of the gun by itself is not an economic activity. And then the court goes on, and I'm not exactly sure why, to the substantial effects test. It doesn't really fit, to be honest, but I think the court was trying to make some doctrine here. So assuming, though, China, I'll go on to you for a minute. China, tell me, does the court say that possession of a handgun has a substantial effect on interstate commerce. What does the court say here?
Initially, I believe that it wasn't.
You're right, the court said it doesn't. Why not?
Because it's not in regulation.
What, let's try this. What is the interest in layman's terms, like you and I are talking, we've never taken ConLaw before, right? If I said, what's the effect of some kid bringing a gun to a high school in San Antonio, what would you say the effect is?
Directly.
Yeah,
Directly affect the environment.
yeah, how would it affect, I mean, I'm being pedantic here, but what's the effect, right? What's the effect of students knowing that some dude has a gun in their building?
Because other students in danger.
Yeah, they're afraid, they may not study as well, they may avoid classes. And take it one step further, right? What's the consequence of students being afraid in class?
They won't go to class.
They may not go to class, right? And let's go one step more than that, right? Well, what's the consequence of kids skipping school?
Kids will eventually drop out of school.
They drop out of school, my God. And what's the consequence of kids dropping out of school?
They won't get employed.
They won't be smart, won't go to college, won't get jobs. And what's the consequence of kids not getting employed, not getting jobs?
The economy will affect.
Ah! Thank you. It took you 6 rounds, right? We can play this game all day, right? How many rounds of and then what, and then what, and then what, till we get to interstate commerce? You have kids, some of you, right? Mommy, and then what, right? You know what I'm talking about, right? How many and then what, mommy, and then what does it get to you? So we start with a kid bringing a gun to a school. People are afraid if they don't study. They don't say they get bad grades. They don't get good grades, they won't go to college. If they won't go to college, they won't get jobs. And if they won't get jobs, they won't have an effect in interstate commerce. Are we done? Constitutional? No? Rosario, why is that not enough? Right? Why is that not, I mean, I just gave it to you 5 or 6 layers. It makes sense to Justice Breyer. Well, why is it not enough?
I think it was you mentioned that eventually everything should lead to that.
Yes. What's the problem when this game I just played with China, we'll call it the inference game, right? Where I pile one inference on top of another and on top of another. What's this inference game? What's the cost of doing this sort of inference game? Is there any limit on that?
No, it was just unlimited powers.
And then what's the problem with having unlimited federal power? Why can't we have that? Does it?
Well, I mean, it says that police powers reserved to the state.
Ah, right. Very good. So even though we have these New Deal precedents that are very broad, the court always maintains this one principle. Congress does not have a police power. The states have the police power. Congress has limited enumerated powers. The states have a general power. They've never abandoned that. I mean, they probably should, to be honest, right? But they've never abandoned the principle that the states have the police power, the federal government has only the enumerated powers. Right? Okay, everyone with me on that? So here, what the court says is, if we start playing this inference game I had with China, right? Don't go to school, they get bad grades, yada, 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 right? If we start playing this game, there are no limiting principles. Therefore, we can't play that game. But wait a minute. Adiyami, didn't we just do Wickard? And they said, well, maybe farmer Filburn doesn't grow enough wheat by himself, but Filburn does it, and his neighbor does it, and his neighbor does it. All these people start doing this wheat, and they go to the market. Didn't Wickard and the aggregation principle pile inference on top of inference?
It did, but in a different sense.
Okay, tell me how.
Lopez differs from Wickard in the fact that Wickard did concern economic activity. The aggregation of the sale of wheat would have had a large effect on the economy of interstate transactions or commerce.
Very good.
While
very
Lopez,
good. Keep going.
violence, though it can be expensive and it can have the effect, it doesn't aggregate to the point where it have a large economic impact on commerce.
Exactly right. And that is the central premise of this statement, right? The central premise of the statement is you only get to the inference game when you have an economic activity. Carrying a gun by itself was not an economic activity. In the next case, Morrison, domestic violence by itself is not economic activity. When you do the Obamacare case for next class, the class after, I can't remember, that is economic the court said that's not economic activity. The failure to carry insurance is not economic activity. This is why when the Obamacare case was being litigated, all the law professors were like, of course, substantial effects. But the threshold question is, are you dealing with an economic activity? If the answer is no, you never get substantial effects. You have to go to necessary and proper. And that is where Obamacare died, at least partial death, I suppose. As a colleague said, it died on the table, but survived the operation, so to speak. All right, so everyone get that aspect of Lopez, okay? I encourage you when you're making your outlines for this class to use Rehnquist's opinion in your notes, because even if you disagree with the new stuff, he gives you a very good summary of the old stuff. So he describes 3 categories of economic activity that Congress can regulate, right? There are 3 categories of economic activity. And you can remember these with an acronym, or what they call a mnemonic device. CIA, right? CIA. Channels, instrumentalities, and activities with a substantial effect. I'll go through these one at a time. Activities. So Congress can regulate the channels of interstate commerce. This is like Hearts of Atlanta Motel, which refers to like things like hotels. How are people moving from state to state? They can regulate the instrumentalities of interstate commerce, which basically refers to things like railroads. Someone's going to ask, what's the difference between a channel and instrumentality? Not much. They're basically the same thing. There's not much difference. The third one is where all the action is. Economic activities that have substantial effect on interstate commerce can be regulated as well, right? In this case, the carrying of the gun is not a channel of commerce, it's not an instrumentality of commerce. It's an activity, but not one of an economic nature, okay? Therefore, it is not within Congress's power to regulate it. Okay? Okay, so we know it's not a Commerce Clause case, right? Right? We know it's not a Commerce Clause case. So, Rachel, since it's not a Commerce Clause case, what do we fall back to? What's our, as Justice Scalia said, the last best hope of federal laws? What do we turn to?
Necessary and proper clause.
Yes, and again, please, for your exams, don't forget this, right? Even after you say this is not within Congress's commerce power, you need to go on to necessary and proper, otherwise you're not complete. And that's like between a B and an A paper. I'll tell you that right now. I can warn you that's exactly what's going to be the difference. Give me half, skim milk answer, I want the whole milk, okay? It's a Ginsburg line from the Windsor case we'll read later. All right, so Rachel, how does this thing shake out under necessary and proper then?
So I think the argument would be set up as in order to ensure that students receive good education and become, I don't know,
Derek Zoolander sense for kids who can't read good, like that?
active citizens in our economy, it's necessary to ensure that they are safe and cannot
But which
bring.
enumerated power is that pursuing though? Because remember, necessary and proper, you can use a lot of different means, but you have to use them to get to an enumerated power. So which enumerated power are you working with? Again, like use the Bank of the United States as an example. The bank itself was in commerce, but they did have the power to coin money, to regulate commerce in several states, right? To trade, these sorts of things.
Right, I think that was under the collecting or the taxes.
Good.
I mean, I think you might be able to argue it that way, but again, it's such a stretch.
It is a stretch, isn't it?
Yeah.
So what enumerated power can the government try and rely on? You're a government lawyer. What do you rely on?
I can't remember which one is under the collecting taxes.
Well, this is a criminal. What is Congress's concern about criminal laws?
That it would hurt the general welfare of the public?
Okay. So this is an important part of Lopez. We've already done with Commerce Clause, right? We say it's not an economic activity. But Congress can regulate local activities under its necessary and proper powers if it's part of a broader, comprehensive regulatory scheme. And to give you a preview, this is Scalia and Raich. This is what Scalia is talking about in Raich. Right? Locally grown marijuana, perhaps they can't regulate under Commerce Clause, but they can regulate under Congress's necessary and proper clause because you have a nationwide market of marijuana. Okay? So here, had Congress explained that local possession of firearms impacts the national educational market, which Congress asserts a power to regulate, right? Then it's okay. Let me say it again. If Congress is trying to regulate local activity as part of a broad regulatory agenda, and they make findings that to stop guns from harming our national economy, we need to do it at the local level. That could perhaps work under the necessary and proper clause analysis. But Lacey, did Congress here make any findings whatsoever about how local gun possession impacts the national market for education and employment?
Under the necessary and proper, or?
Did Congress make any findings here at all?
No, but it's unconstitutional.
When Congress passed a statute, did they make any findings about how local gun possession can affect the national economy? This is an important point.
Oh, in the instance?
In the statute itself, did Congress make any findings?
No.
You guessing?
Yes, because it's an absolute question.
What did Rehnquist say? Did Congress put any sort of hook, what's called a jurisdictional hook, to connect this law with the problem of nationwide gun violence and anything else?
Oh, yes, they did. I found it now. Oh, they didn't?
They didn't.
Well, okay.
Well, no, name tag? Benjamin. Did Congress make any findings on this? Do they have what's called a jurisdictional hook to explain why this falls within their federal jurisdiction?
I think they argued that it had like a ripple effect.
Who's they?
Schools that would have a ripple effect from education.
When
that
Congress
impacted-
passed the statute, in the statute itself, are there any of these findings? This is a very important point, we should review this. Daniel? What did Congress find in the statute? What conclusions did the Congress draw? Not the government in court. The government in court made findings about the ripple. Yeah, Andre?
Are we talking about the dissent? Is that in this where they talk about how they could have found that gun-related violence?
They could have,
Yeah.
but did
But
they?
they didn't.
They did not. How do we know this? What does Rehnquist say? What did Congress not do here? Who was lazy here, right? Who didn't do their damn job?
Congress?
Yes, thank you. Thank you. Exactly right. When Congress passed the statute, they got lazy. They got lazy. They did not include what's called a jurisdictional hook. I used this phrase a few times. A jurisdictional hook. It sounds very vulgar, but it's basically a way to connect the activity you're regulating to a national economic marketplace. Congress could have said, we recognize that mere possession by itself is not an economic activity, but we have an interest in creating a nationwide market for education, and as a necessary and proper way of doing that, we will regulate local gun possession. They did not do that. And Rehnquist says the failure to do that is why this law fails. The court won't make up a rationale. Justice Breyer in Dissent says, oh, they could have thought this, and they could have thought that, and they could have thought this. Rehnquist says, we're not going to make it up. Now, the question is this consistent with Wickard? Right? Didn't Wickard say, well, Congress could have conceived that in the aggregate, all these farmers together could have substantially affected interstate commerce? So again, we're seeing a tension with Wickard and the New Deal cases. I saw a hand somewhere. Jackson.
So what enumerated power are they using for necessary commerce clause? Are they using the commerce clause?
So there's no
didn't work.
education clause.
Right.
So it's commerce clause.
So the okay, that's what they.
Basically, or maybe the spending clause, because Congress has no power to regulate education, but we have a Department of Education that does just that. And it's mostly through the commerce clause and the spending clause.
So the commerce clause didn't work at first, so they go to the necessary profit clause, and then they go back to the commerce clause.
Exactly. Yeah, but the court says here, they didn't hook it together, right? You said connect, I'll use the word hook.
Okay.
They didn't hook the necessary and proper argument back to commerce.
Is that what they mean by the findings?
Yes, the findings are how do you make that connection, how do you do that jurisdictional hook? That's the key. Yes, ma'am.
On the same token, also, is it synonymous to, when it talks about jurisdictional element?
Yes, it's the same thing, yeah. Yes.
In this, up to this point, Congress kinda had, was it using the Commerce Clause because it knew that it could get away with it?
Got lazy.
And it just like.
The Supreme Court hadn't struck down a federal statute on Commerce Clause grounds like in 60-something years. So basically they got lazy. They thought, oh, whatever, we'll just pass a statute, we'll save 20 minutes by drafting findings.
So it's like.
And I'll give you another, I'll answer your question differently. While this case was pending, right, the Fifth Circuit Court of Appeals struck down the federal law. After that happened, Congress passed another version of the same statute with the jurisdictional hook. They passed the exact same statute with like a couple extra sentences added. And then President Clinton said to the Supreme Court, hey, look, we have this other statute. And the court said, no. Lopez, right, was convicted on his old statute. You can't bait and switch the guy, right? You can't convict him retroactively under a new statute. You convict him under his old statute, that's what we're going to consider. So we actually still have a gun-free school zone act on the books today with the requisite finding, but the one that I think he was the only person ever actually convicted under it, and his conviction was reversed by the Supreme Court. I said yes. Oh, I sorry,
Yeah, I was gonna ask, so what's to keep this from, so now we have this law, federal law.
Yeah.
So how are we not in a situation where our government decides like across the board school, I mean, if they have the ability to control federally like what goes in and out of our schools, even though we already have state laws that say we're not gonna allow this.
Yeah, I mean, let me answer your question a little differently, right? Let's say that Texas, and Texas does, allow concealed carry in schools, right? Let's say a state wants to allow teachers who are licensed carry holders to bring a firearm to school. Let's say a school doesn't have the budget to put security guards at every school, and they said if you're a teacher and you have a license, you can carry. Under federal law, they'd be criminals, right? So when you have this sort of federal law without the exemptions for local carry holders, they're not law enforcement, they're teachers. You displace state sovereignty, right? When you say there's a single one-size-fits-all policy, that the entire nation must have this gun policy, you intrude on the prerogative of the states to protect their own police power. So that's an undeniable aspect. So as you expand federal power, state power contracts. But here, there was a very slight contraction of federal power and a very slight expansion of state power. Really.
But doesn't Gonzales kind of
Yes, we'll get to Gonzales in like 20 minutes. Yeah, we'll get there. Gonzales v. Raich is a contradiction, yes. In fact, Randy Barnett, the co-author on the book with me, he argued Raich. And it's a case that brings some great sadness whenever we talk about it. We'll get to Raich in due course. Okay. So let me summarize the majority opinion before I get to the dissent. Chief Justice Rehnquist, who begins with first principles, explains that this is not a case involving a channel of commerce. It's not a case involving the instrumentality of commerce. It's not an economic activity. Mere possession is not. And because Congress failed to articulate what the economic activity is, we go to necessary and proper. And here again, Congress failed to make the findings about what sort of national marketplace this regulation is serving. And therefore it fails under commerce, it fails under necessary and proper. The regulation cannot stand. Okay? The regulation cannot stand. Justice Breyer Okay? Justice Breyer, in contrast, plays the inference game, which I played with China a few minutes ago, right? He says, well, gun violence is a serious problem. That has an effect on classroom learning, and that effect on classroom learning prevents a substantial threat to trade and commerce. The majority says if we had played this inference game, we pile inference upon inference, everything is included. There's no conceivable limit on federal power. Right? The majority does acknowledge, I think, what is Justice Breyer's greatest strength, in his opinion, which is certainty. The court here rocked the boat. If you were alive, and most of you were, if you were paying attention to the law in 1996, eventually I'll say this. You weren't?
I was a year old.
Yeah, eventually you'll get to no one's alive then. The thing about teaching is, I started teaching my 28th birthday. My first day was my 28th birthday. I get older, you don't. It's a weird thing where, you will, of course, right? You'll age with me, but a 2L or a 1L, you stay the same age, 25, 26. So the gap grows and grows and grows. But Justice Breyer, I think the greatest strength of his opinion is, look, we need certainty, right? For decades, the court had established a rule that Congress can do it once. And this injected uncertainty. If you think, professors freaking out with Trump, look at this. They were going insane. It's like, oh my God, Gun-Free School Zone Act. This was such a trivial law that affected one human being on planet Earth, right? Lopez, right? It was such a small law, but this was an earth-shattering decision. And even, I told you, Congress reenacted the law, the exact same law with 2 extra sentences, and that was fine. It's still in the books today. So in the final analysis, this is not an economic activity. It does not substantially affect interstate commerce, and it cannot be sustained under the necessary and proper clause. We decline to proceed any further. I think that's the key word. In other words, we're not overturning Wickard, but we're not going any further. Okay, Justice Kennedy has one of his usual concurring opinions where he's a little bit of this and a little bit of that, and I don't know how I feel and whatever. Stability, we'll get there later. It's not too much important here. Justice Thomas is what he would call himself an originalist, that he tries to interpret the Constitution according to its original understanding, that is how people at the time of its ratification understood commerce. And he basically says the substantial effects test is a fiction, right? The court made it up, it's wrong. The word substantial effect appeared nowhere in the Constitution, and Congress can't regulate substantial effects, they can regulate commerce itself. He also says we should limit ourselves to the original understanding of the word commerce, which means intercourse, trade, not manufacturing, not agriculture, not mere possession. Also, I suspect Justice Thomas is not particularly happy with McCulloch v. Maryland. I think he's in the Chief Justice Chase school of thought and not in the Marshall school of thought, where the Bank of the United States perhaps went too far. I think even with Thomas. I'll perhaps get there. And he finally mentioned the 10th Amendment, and it says this sort of doctrine turns the 10th Amendment on its head. These are matters for the local government, not the national government. I more or less described Breyer's dissenting opinion with this piling inference by inference. But I want to make clear, he is correct that the court is not being faithful entirely to Wickard. The fact of the matter is Wickard didn't require specific findings about connecting this activity to a nationwide marketplace. Rehnquist kind of fudges it, they didn't. So there is a shift in the doctrine which you have to be aware of, that merely Congress putting these findings in is not enough. And the reason why this is important is in the next case, in Morrison, Congress put a boatload of findings in, and it still wasn't enough. So it leaves a bad taste in your mouth here talking about the findings. Okay. Questions on Lopez? Very important case. Brandon.
I totally missed where Rehnquist went from commerce to necessary and proper.
You're not alone. He didn't do a very good job in that one. You're not alone. He fudged it. In fact, I think Thomas does a better job in his concurring opinion.
But I mean, what key trigger words?
He doesn't. And I don't, again, I'm not blaming Rehnquist, but the doctrine was not well developed here. I think the best opinion you're going to read on this is Scalia and Raich. Scalia and Raich explains it so clearly. You know, I'm a huge Scalia fan for his writing. You can agree with him or not, but his writing is so clear, and there's never any doubt. Here, Rehnquist curves a little bit. He fudges it to try to make it fit within Wickard. It's not a good fit. But when you read Scalia and Raich, there's no doubt about how this works. And if you want to read the Chief Justice in the Obamacare decision, he makes it really clear. So here, Rehnquist didn't do a good job with this. But yeah, Andre.
So, up to this point, they just played their 6 degrees game.
Yeah.
And basically.
Well, I like that. 6 degrees, that's good. I like that.
Yeah, and got whatever they want passed.
Right.
Up to this point.
Yeah,
For 60 years.
pretty much.
And nobody questioned it.
Well, people questioned it, but the justices did not. The votes weren't there. Like, there were lots of challenges to these various laws, and all the challenges failed. That the court even took this was significant. Right? A lot of people thought the court wouldn't even take this case back in the 95, 96, whenever it was. So after 95 and 96 with Lopez, for about 5 years, you know, lawyers were like, oh my God, the New Deal's over, it's going to be, you know, Armageddon apocalypse. And we come to the next case, United States versus Morrison. And this is a 2000 decision. And the facts in this case are not even in your book, I don't think. But they involve Christy Brzonkala. She was a student at Virginia Tech. And she asserted that she was sexually assaulted by 2 football players. Long before we know about this sort of stuff, this was going on. His name was Antonio Morrison and James Crawford. So Brzonkala asserted that she was sexually assaulted by 2 members of the Virginia Tech football team. It probably won't surprise you that the local, what's the name of the town Virginia Tech is? Something Bird.
Blacksburg.
Blacksburg, thank you. That the local Blacksburg PD didn't arrest these football players. They were never charged with anything. Not surprising. Usually, when the police don't arrest the guy, you have another option, which is civil litigation. So, by the way, I think the players were suspended for a game or two, like maybe a semester. It wasn't very long. I don't think they missed any games. So she wanted to sue. Now, of course, she could try to sue the football players. I mean, they don't have any money. I mean, there are no deep pockets. They're sophomores and juniors. Maybe they'll make it big in the NFL, but I don't think either of these guys ever made it big. So then she said, okay, I want to sue the university, Virginia Tech. I mentioned this in the first day, but you can't sue a state under the 11th Amendment. You can't sue the state. State universities are part of the state. UT Austin, Virginia Tech, right, University of Florida, whatever it is, they're part of the state. So she could not go to a Virginia state court and sue the state university. So instead, she brought suit in federal court under this brand new law, VAWA, the Violence Against Women Act. And VAWA did a lot of it which has nothing to do with violence against women. It's all gender-motivated violence, not just against women. There's a lot of stuff in there. But the provision we're talking about here is very specific. It said that you can sue a state or any state institution that engages in some sort of gender-based violence. I'm summarizing a complicated statute. But in short, because the university didn't investigate and prosecute this sexual assault, that the state university itself violated VAWA. And so she wanted to sue in federal court the university. Now we're going to study this case again later in the semester for the question of whether Congress has the power to allow the state to be sued. That is, whether Congress has the power to waive the state's sovereign immunity. We'll do that later. But today, the threshold question is, can Congress even regulate domestic violence? Or to put the question a little more precisely, is domestic violence an economic activity? Right? Because go back to our test, right? we only get to substantial effect if we have an economic activity. So first, our question is this. Andrea next, or Elizabeth? Yeah, she's pointing at you, right? Thank you. I know it's in that background. Elizabeth, is domestic violence by itself an economic activity? No, why not?
It's not production, manufacture, bartering, I guess, bartering.
What is economic activity?
Well, it depends on who you're asking.
Oh, good. Oh, I love that answer. Thank you. I'm asking you.
Well, it depends on.
All right, I'll make it more fair. I'm asking Chief Justice Rehnquist. I'll make it easier for you. To put you on the spot.
Honestly, I don't remember who said what, but was he majority, minority?
Chief Justice Rehnquist is the majority.
Majority. Then it is.
Okay, why? Why is domestic violence in Blacksburg, Virginia, not an economic activity, according to the majority?
It doesn't relate to like any of the channels.
Good. Thank you. Okay, good. Right? It doesn't fit in the channels. It's not instrumentality. And then we get to our last point, right? Is the violence still an economic activity? The court says not. Domestic violence, and really any sort of battery, rape, murder, pick whatever crime you want, right? These are all crimes that are historically solely within the federal government's police power, right? Long before the federal government had a murder statute, if you want to talk about a federal murder, right? That's not just shooting someone across the border, right? It's a little complicated. But long before the feds had any crimes, Virginia had its own criminal code. Virginia predates the Union by some time. So because domestic violence is not economic activity, where do we go to next, Zach? Exactly. Okay. And tell me, what is the necessary and proper clause analysis look like here?
Is it necessary and proper for them to regulate this, to carry out?
Carry out what? What enumerated power?
The body of violent crimes.
Yeah. Right, and this is the question again, is this commerce, right? The argument advanced by the government is this. When you have domestic violence in universities like here, students don't go to class, they're afraid to go to work, right? They don't contribute to the national economy. Therefore, if you pile it all together, there's a regulatory scheme that's being undercut. Therefore, this is necessary and proper. Is that consistent with Lopez, that sort of analysis? No, why not? Yes. We don't play the 6 questions game, the 6 degrees of separation game. I think Andrea called it that, right? We're not playing 6 degrees of separation here. The actual act itself of domestic violence is not economic. Congress doesn't have an interest in local law enforcement by itself. And they're not able to show, according to the majority, this effect on a national marketplace. Right? Jason?
I would argue that education in itself is a form of commerce. A lot of schools, especially private schools, they can be for profit. The textbooks, there's an entire industry. So if women don't feel safe going to college.
That's Breyer's argument, right? What does Breyer argue in dissent? Yep. What does Justice Breyer argue in dissent? What's Breyer's dissent? It's in your book, right? Yeah. Anyami?
That they should be able to regulate non-economic activity that takes place in economic establishments.
Yes, and that's basically Breyer's argument, right? Even if the act of violence by itself is not economic, it's taking place in the broader context of university campus, which involves money for tuition and money for textbooks and everything else. Right? Everything else. Yes, sir.
I thought the most compelling argument against the dissent was by Rehnquist when he brought up family law.
Ah, tell me about family law. It's a good
So
argument.
there's probably no impact as great to the economy of education as
Yeah.
divorce.
Oh, you are so right about that. Custody,
Yeah.
visitation.
Guns on campus will never have the impact of broken homes.
That's a very true statement. I mean, for most people, the two most important elements of law are family law and criminal law for state of Texas, right? I'm sure everyone in this room knows someone's been divorced, knows someone maybe spent some time in jail, right? Forget federal government, forget whatever, right? State criminal law and state family law is such a higher degree of impact for the everyday man on the street or woman on the street, as it were. So Rehnquist is saying, look, if Congress can regulate local violence by itself, why can't they regulate family law? In fact, I wrote an entire article on this. Congress passed the Uniform Probate Code of how to handle family law nationwide, the Uniform Divorce Law. Could they even do that? There are actually cases involving Indian family law, which is complicated. But generally, Congress stays out of this field with good reason, because it's a local matter. But that's, I think, one of the better explanations about this. Okay? All right. So that's Rehnquist. Okay? That's Rehnquist. Oh, yes, Kevin.
So if this situation causes a lot of donors to drop out and
Bob, you said donors?
donors to
I heard donuts, I'm sorry.
and the amount of students who go to that college drastically drops.
The endowment drops.
Yes.
Look, but that's Breyer's game, isn't it?
Yeah.
That's the 6 degrees of separation.
But would that have a different impact on how you would use the Commerce Clause in this aspect?
Well, but you have to start with this issue. Is it an economic activity? If it's not, the rest of that doesn't matter. You go to necessary and proper.
Well, it's an economic argument.
But the act that's being regulated is the domestic violence, not the university as a whole. Right? This is why no one understood the Obamacare challenge. They said, well, of course healthcare is economic. But the actual activity being regulated with the Affordable Care Act was the mandate. That is, if you go uninsured, you have to pay a premium. Look at the act being regulated, right? In Obamacare, the issue was, is this a regulation of economic activity or a regulation of economic inactivity? Okay. All right. I don't want to do too much more on Morrison because it's largely repetitive of Lopez. One thing I will mention is, unlike Lopez, Morrison had jurisdictional hooks galore. Lots of hooks. Lots of findings. This was Joe Biden's baby. This is like his favorite law, right? The court said, well, those findings are nice, but they're not enough. They're not enough because we determined those are not sufficient. And then in dissent, I think it was Breyer who said, well, this is supposed to be a rational basis review. We're not supposed to closely scrutinize this. This is a departure from Wickard. I think Breyer was probably right about that, but it was upheld. So we have Lopez in 95, we have Morrison in 2000, and a way you can remember them in order, L comes before M. Lopez before Morrison. That's how I remember it. Right? And then Raich, R, comes after M. So Lopez, Morrison, Raich. I remember it the exact same way all these years later. So some of the things you learn in law school stick with you, some don't. That sticks with me. Raich was decided in 2005. And this was, again, another major test to see, was the Rehnquist court serious about this federalism business, or were they just playing around? The Lopez case was fairly, minuscule. It's this Gun-Free School Zone Act involved Lopez, right? VAWA was bigger because this was domestic violence, could affect a lot of people. Raich, though, affected the Controlled Substances Act, drug law. And had this gone the other way, we would have had medicinal marijuana nationwide a lot quicker, but we didn't. So this is Angel Raich. Anyone see what she's holding there in her hand?
Is it a pipe?
What is that?
Here, want to be?
How would you know what that is?
It says it on the caption.
Oh, You're right. Better. This is one of my, whenever I lecture on the road, I always give this as a litmus test. I say, does anyone know what that thing is? And when I'm in New York, it's like, it's vape. And then when we're like, a Christian school, I have no idea what that is. They all know what it is, but they don't want to admit it. Yeah, so here is Angel Raich with a marijuana pipe, a hash pipe, if you will. Here she is, toking from a vaporizer. And here she is with Randy Barnett, who is a co-counsel. This is actually a sad picture. This one she found she lost the case, which was just very, 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 very sad for her. The case itself involved California law. California law permitted people to use medicinal marijuana. You were given this little card by the state, and your doctor would write a note saying that you had some sort of medical reason to have it. Everyone gets one of these. If you have like depression or like your anxiety or you can't sleep well, you get one of these cards. It's like a joke, but whatever. Yeah, O'Connor's like, oh, there's a scheme to keep, whatever. But the key point here is that the marijuana that Raich and another woman, Diane Monson, used was not shipped across the border. It was not from out of state. It was locally grown. And a unique attribute of marijuana is it doesn't really require any sort of interstate commerce to exist. You literally put a seed in the ground, you add some water, you add some sunlight, you add some fertilizer. I've never grown marijuana, but maybe you have. It seems... Oh, come on. Nodding. When I was in high school, I had people grow their little lamps in their closets. Whatever. I'm here, they're there. It's true. They grew marijuana locally, and Raich and Monson were provided it for no cost. So there was no money being changed hands, right? There was no commercial exchange. The feds raided the property of Monson and Raich, and they basically seized a number of marijuana plants. This was a legal activity under state law, but federal law enforcement officials were sent in to take their marijuana. So this was not actually a criminal case. This was Gonzales, the Attorney General, being sued by Raich, who was the owner of these marijuana plants, along with Monson. The lower court actually ruled for Raich and Monson. And this was like, oh my God, this is the next Lopez and Morrison. The court's going to strike down the controlled substances law. Okay. It gets to the Supreme Court, and the case breaks down 6-3. While you may think that the liberals in the court support medicinal marijuana, this was a case about federal power, not about marijuana. And the majority opinion was by Justice Stevens. Justice Scalia concurred. He did not, he groused. I don't think he actually joined the majority. I think it's totally inconsistent, but he concurred in judgment. And then in dissent, you only had O'Connor, Rehnquist, and Thomas. And I think there's a note in your book that explains this, but at the time, Justice Rehnquist was very ill. He died less than a year later. He didn't participate in the arguments. At this point, he was literally phoning it in. Like, he couldn't come to the court. I guess clerks were...
He should have been using the medicinal.
Oh my God, he had cancer. That's too much. Rehnquist he had cancer. He was a smoker. He smoked a chain smoker. So, in fact, Scalia had the smoke detector since Chambers disabled, so he could smoke in the chambers. It's very sad when people with life tenure don't take good care of themselves. It's very sad. Justice Ginsburg does push-ups and planks, which is in very good shape, and Kagan apparently is using her trainer, so they're going to be around for a while, I suppose. But then we get to the case. So the question you can think about is this simply Wickard, right? Congress can regulate locally grown wheat, so can they regulate locally grown marijuana? Okay, so, I forget where I was. Anthony, is this not Wickard, like, why is this case any different than Wickard? Is it?
I don't think it is, but
Why not?
because it's the same, they're still growing it, and they said there was already a market for marijuana, even though it was illegal.
Now, let's start with our test, right? We know from Wickard that growing wheat from farmer Filburn was an economic activity, right? Is growing marijuana for local consumption an economic activity? What does the court say? What does the court say? Is growing wheat, by Justice Stevens' account, an economic activity? Case, you got it? How does Justice Stevens define what is an economic activity?
What, he defines it by using the substantial effect.
What are-
Is that what you're doing?
How does it define economic activity? That's what I want first. How does Justice Stevens define economic activity? He does it in a very strange way, very strange in my mind. How does he define economics? Anyone? I'm looking for? Is that right?
The production, distribution, and consumption.
Where does he get that from? Andre? Which dictionary?
Oxford?
No, I wish it was Oxford.
Webster's.
Webster's, which edition?
Third New International.
Webster's third. Justice Scalia hated Webster's third dictionary. He wrote this entire missive how Webster's third said that imply and infer mean the same thing. He ridiculed Webster's third. In fact, he loved Webster's second. And in his portrait at the Supreme Court, which I have a picture of in your dictionary casebook, which you won't have, but I have drafts of. In the portrait of the Supreme Court, he has a copy of Webster's second sitting on the desk. So, Justice Stevens looks to Webster's third dictionary from 1966 to define a term in the Constitution drafted in 1787. Why Webster's third? Because he uses the most broad definition humanly imaginable. So how's it defined? Economics, says the editor of Webster's third, refers to the production, distribution, and consumption of commodities. Consumption of commodities means smoking dope, right? It does. Production means growing wheat. Stevens found a dictionary that embraces, I think O'Connor said, the entire extent of human conduct. Right? Anything you can think of can fall in that category. So, Case, I'll come back to you. Is possessing a gun falls within the production, distribution, and consumption of commodities?
Yes.
I think it does. What about domestic violence?
Yes.
More of a stretch, right? But I think gun possession probably would fall within that category. So, someone asked me this before, I think it was Brittany. Raich dialed back Lopez and Morrison. It dialed it back. It defines economic activity at such a broad level, right? So we go to our CIA, right? The A right now is so big, it doesn't even matter. Because basically everything can be an economic activity. And once you get to an economic activity, you can go to substantial aggregation. And then you know the end, this is 6 degrees of separation, right? Well, if Raich grows locally grown marijuana, then she won't need to buy marijuana from other states, and that will affect the price in Cleveland, and therefore interstate commerce. Something like that. It doesn't even matter. You can make it up, right? But the key move by Stevens, really the only important part of this decision was say that the local growing of marijuana is an economic activity based on Webster's third. Okay? I don't want to talk much more about the majority opinion because there's really not much there. It's that's the opinion. The substantial effect stuff is easy. So anything on majority? Let's go Scalia. This is where it's at. This is probably one of the most important opinions Scalia ever wrote. I don't know that I agree with the outcome, but his analysis is rock solid. And Scalia basically says that this is not economic activity. He doesn't come out and say it. A lot of critics of Scalia assert that this is an opinion based on the war on drugs. And Scalia perhaps modified his jurisprudence because it involved drugs. Justice Kennedy, who had joined Lopez and Morrison, may be in the same boat. There's some story that one of the members of his family overdosed on drugs and he has a soft spot for drug addicts. I don't know. It might be all conjecture. But it's tough to reconcile the votes of Scalia and Kennedy and Lopez and Morrison to Raich. It really is difficult. It's possible, but it's difficult. So Scalia explains that the correct analysis here is the necessary and proper clause. And he doesn't quite say it, but the only way you get to necessary and proper is if you don't have some sort of economic activity. Because if you have an economic activity, you stay in Commerce Clause land. You don't need to go to necessary and proper clause. Okay? So let's walk through, Carlo, walk me through Scalia's necessary and proper analysis.
Well, for necessary and proper, I believe he was more concerned about whether or not it was reasonably adapted.
Where does he get this reasonably adapted language from? Or actually plainly adapted, if you want to use the exact phrase. Where does he get this plainly adapted language from?
Would that have been Lopez?
No, a little bit older than Lopez. Way older than Lopez. Where's this plainly adapted language from? One of the first cases we studied.
Madison?
A little bit later. McCulloch v. Maryland, right? In McCulloch v. Maryland, very good. Chief Justice Marshall said, for the ends to be constitutional, the means must be appropriate and plainly adapted. What does that mean, appropriate and plainly adapted? The way you go about it has to be okay, right? That's pretty open-ended. So the test articulated by Marshall for necessary is fairly open-ended. Convenient, conducive, helpful. So if Congress wants to, I'll use my favorite example, buy horses and carriages to allow the mail service to deliver post, they can do that, right? That's plainly adapted. But so far, in the cases we've studied, we've only talked about necessary, right? Here, Scalia articulates, I think for the clearest, and the first time ever, that necessary and proper are not the same. And they're separate inquiries. Kevin, what does Scalia say about proper here?
A law is not proper for carrying in execution of Commerce Clause when it violates the constitutional principle for state sovereignty.
Very good. So you haven't studied this case yet. I think you'll read it for class next week or the week after, I can't remember. Called United States versus Prince. United States, P-R-I-N-T-C, Prince. And this case concerned a federal law that required local sheriffs to perform background checks when someone wants to buy a gun. So if you're a sheriff in Raleigh County, Montana, and someone in your county wants to buy a gun, they have to come to you and do a background check first before they get the gun. The court struck down this law, 5-4, saying that this law was an aspect of commandeering, that they were basically taking over local law enforcement. But the important part of that decision was the court said, this is not a regulation of commerce. It's a regulation of local law enforcement. But if it's done as part of a broader regulatory scheme, it's fine. Even if it's necessary to assist law enforcement to do these background checks, it's not proper. And why is it not proper? As Kevin said a minute ago, it intrudes on the principle of state sovereignty. That when a law goes too far into a state's prerogatives, it's not a proper application of federal law. So here Scalia articulates briefly, but he does, What makes a law improper? We'll come back to this with the Obamacare cases. Okay? So Scalia says, with that frame, the application is straightforward. Congress has an interest in regulating the nationwide market for marijuana. It doesn't matter that that marketplace is illegal, right? Congress can regulate the nationwide marketplace for marijuana. What happens if someone grows locally grown marijuana? It frustrates that nationwide scheme. It interferes with it. Because if Raich can buy marijuana from her next door neighbor, she won't have to go to the drug dealer to get it, and that inhibits Congress's ability to regulate the marketplace. Yes, ma'am.
I think it was Ashley who asked last,
12 days ago.
yeah, well, I think it was before that, where she stated when we were talking about the oil and the candle case, where I feel like this is more of the same thing, where they were just trying to push you, and it was more, well, that's what the sense, it was more of them regulating something, and that's not what something was about.
Yeah, Congress wants you to be in a marketplace they can criminalize, right? Because basically when Raich buys local marijuana, she is outside the federal government's prerogative. She's not within their thing. For her to need to go to a dealer on the corner to buy pot, that can be regulated. Right. So basically what California tried to do is carve out an exception to the federal regime. And what Scalia says is, this law interferes with this regulatory scheme nationwide, that California can't carve out a piece of it. And because California is trying to interfere with this federal regime, that is why it runs afoul of the necessary and proper clause. Drugs are fungible. They're never more than a moment from an interstate market. Now, here Scalia tries to distinguish, and I said tries, I give away my opinion. He tries to distinguish Lopez from this case. Why is the possession of guns non-economic activity, but the possession of pot is? Scalia says, in Lopez, the gun was not part of a large regulation of economic activity. But here, there is a large economic activity, which is the interstate drug market. What about proper? That this intrudes on state sovereignty? Scalia rejects that. Congress has long regulated drugs across state lines, so Scalia finds no problem. Something of a chicken and egg problem there, because if Congress couldn't do it in the 1970s, they would have had it all along, right? They've only been regulating this for 30 years because the court only started regulating federalism 5 years ago. So for decades, Congress would have whatever it wanted. If Scalia was in the court in the 1970s, perhaps it would have been a different outcome. All right, so that's Scalia, right? Even if locally grown weed is not an economic activity, it is part of a broad regulatory marketplace, and California's law interferes with that marketplace. Okay. Jackson.
I guess like going back to Lopez, if they're not a marketplace for guns.
Of course there is. Of course there is. Now, Congress didn't articulate that, right? They didn't make the finding. They didn't put the jurisdictional hook in there. Okay. But of course there is. But the point is, you don't need to make those findings because the court tradition would have pulled it anyway. So you have to understand Raich as a retreat, Lopez and Morrison. It's like, all right, guys, I think we went too far. Let's, come back in a few steps. And the fact that it was a drug case, I think made it a bit easier for Scalia. But I want you to say his opinion, because he explains the relationship between commerce and necessary and proper far better than Rehnquist ever did. I don't think Rehnquist did a good job on that. I think Zach is someone asked that before. It's not Scalia's where it's at. And when you get to Roberts in the Obamacare case, crystal clear. Until you get to the taxing power, then it goes awry. But the necessary and proper part's crystal clear. All right, Mark, you have it?
Yeah, so the enumerated power that was expanded upon by necessary and proper would go back to like what Rachel said before with general welfare?
No, not general welfare, that's not a power, it's commerce. Yeah, it's always commerce. What does O'Connor say? Who am I up to next? In the back. David, what does Justice O'Connor say?
What was the question?
What does Justice O'Connor say? What's her dissent?
Well,
She.
I think she's saying that
There was I'll give you another second to think about it. Very often on the court, that for a time that Justice Ginsburg and Justice O'Connor were only two female justices, and it happened more than once that a lawyer confused the two of them. And recently, a lawyer called Justice Ginsburg Justice O'Connor, even though O'Connor retired like 8 years ago or 9 years ago. So it still persists. People did call Chief Justice Rehnquist Justice Rehnquist, and he would always correct them, saying, "My name is Chief Justice." Occasionally, people will confuse Breyer and Souter. They kind of look alike. Not really, but they're the same. I guess when you're nervous up there, you get confused. Anyway, David, now you've had sufficient time. What did Justice O'Connor say in her dissent?
That, so basically, first you have to figure out if the possession of marijuana is an economic
Good.
activity in the first place.
Good, and then?
Substantial effect on interstate commerce.
Uh-huh.
And if that's an appropriate subject of federal regulation.
Good. Okay, so David, finish it up for me. Does O'Connor think that the locally grown marijuana is an economic activity? What did she say? She's in dissent.
No.
Yeah, she said no. Why is simply having pot or growing marijuana not an economic activity to O'Connor?
Laboratory, experimental?
Good, yeah. She invokes this famous case, a case called New State Ice versus Liebman, 1932. And there was a dissenting opinion from Justice Louis Brandeis. And Brandeis explains that a single courageous state may, if its citizens choose, serve as a laboratory and try novel social and economic experiments without risking to the rest of the country. So if California wants to experiment as a laboratory with this drug, they can do that. And what O'Connor says is if we read economic activity as broadly as does the majority, states can never experiment. So as a result, this is a very strong opinion for federalism. Okay. Now, Brandon, I think you're next. How does O'Connor square this with Wickard? Why is this case different than Wickard? Why is this case different than Wickard?
Because Wickard was selling wheat commercially.
Okay.
And these two women were growing cannabis on their own, and they weren't selling the product.
Mm-hmm. But couldn't Congress regulate the wheat that Farmer Filburn never sent it to market? Wasn't that the point? They could aggregate it?
Yes.
So what does O'Connor say in response to that? How is Wickard different? Why is Wickard different? Amber?
She basically said that Wickard's different because it didn't stop the actual growing of wheat. It just kind of condensed it and made it to where.
Well, no, they said if you grow more than a certain number of bushels, you'll hit with a penalty. Why is this case different from Wickard, from O'Connor's perspective?
Well, she said it did not hold or imply that small scale production
Yes,
of commodities.
exactly. The Agricultural Adjustment Act confirmed that Congress didn't reach small-scale, non-commercial wheat farming. It only reached wheat growing above a certain level. Here, if you grow a single bud of marijuana, right? Bud's the unit of measurement, right? I don't even know. It's funny. Randy, who is like me, he always says he's never smoked marijuana, neither have I, because he wants to say, from a court, I've never smoked marijuana, I'll defend it. But I think Randy told me one day he probably will when he retires to try it. But a single bud of marijuana, one seed, I suppose, that itself is within the federal power. And O'Connor says that in the Wickard case with the Agricultural Adjustment Act, they exempted small quantities. Okay. O'Connor then says, even assuming this is economic activity, the government has made no showing that the use of homegrown marijuana would have a substantial effect. That's probably not right under the aggregation principle. I think she's still running away from Wickard. There's this tough tension there. She goes on to necessary and proper, and she says that this is not a proper use of federal power because it intrudes upon state sovereignty. And once we get to substantial effects, we're playing the 6 degrees of separation game. We pile inference upon inference. Justice Thomas dissented, and he said, our federal government is one of limited powers, and if Congress can regulate this, they can regulate everything. Justice Thomas has said this in every single case involving the Congress was ever, it's like on a macro at this point, it's repeated over and over again. But people have yet to respond to him. Okay. Questions on Raich? Yes.
Do you think that had Chief Justice, I'm sorry, I don't know what the name.
Rehnquist.
Rehnquist would have been the decision?
Well, I mean, he dissented. He joined the dissent. It was 6-3, so he couldn't have flipped it 5-4. He couldn't have flipped it the other way. So I think the decision was what it was. Scalia changed sides. Kennedy changed sides. That's all you need.
Just for that, had he been live, he could have made a stronger argument.
You think so? I mean, it's possible. I mean, the Chief Justice was a very persuasive guy who's, even those who didn't agree with him, he was well respected. His, you guys have oral arguments coming up. His rule is at the exact time the light turns red, he cuts you off. And he would stop lawyers in the middle of their sentences. Cold, right? When he held a conference, if there was a conference for, say, 30 minutes, he would stop it at 30 minutes. He was very strict with time. The new Chief Justice, Roberts, he's a little bit more liberal. He often lets the lawyers go over time. He lets the conference run a little bit late. And so they're pros and cons. So maybe you're right. I don't know. Maybe Rehnquist could have whipped the votes better, perhaps. Anything else on Raich? So let me try to synthesize Lopez, Morrison, Raich before we go on to Dole. Lopez was earth-shattering move that now the court would police Congress's powers. And then Morrison seemed to say, we're going to keep doing this. We're going to extend this doctrine and see, is this actually an economic activity? But once Justice Stevens adopts Webster's third dictionary of what an economic activity is, it virtually consumes the entirety of human conduct. And once you get to economic activity, you have the substantial effects test. And with the substantial effects test, anything goes with aggregation. Scalia's opinion on necessary and proper was important because it articulated, even if it's not an economic activity, you still get a lot of deference under necessary and proper. But it won't be until we get to the Obamacare decision next class, or the class after, I can't remember, that we actually talk about how we apply necessary and proper. Okay? All right. Questions? Yeah, Mark.
So I agree with your explanation of how Scalia was able to get the enumerated power of commerce to cover the marijuana industry because it prohibited the regulation of the criminal marketplace. But going back to my question before, can you ever break out from the first enumerated power general welfare alone? Because you can't.
No.
So that's really only.
Well, look here. All right. Occasionally I go to the dry cleaners. I leave my Constitution at home. I'm sorry. I feel naked. I always carry a spare. I'm kidding. I give these away all the time. But actually, go to Article 1, Section 1. Pull out the page, Mark.
34. Starts at the bottom of 34 into 34.
Yeah, Article 1, Section 8, Clause 1. Thank you. And it says, this is actually a perfect bridge to the next case. Thank you for that. The Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. Okay, so ask me a question again.
So in the middle of that.
Right. What does it say in the middle?
To pay the debts and provide for the common defense and general welfare of the United States.
That's the topic of our first case, isn't it? See, you knew this. You knew asking that question. You knew the bridge. Where is the spending clause, Mark? Finish up. We have this entire chapter in your book called the spending clause. Where's the spending clause? You see it? Congress shall have the power to spend money. Where's the spending clause?
Article 1.
Okay, where is it? Where is the spending clause? Where's the spending power?
is this not, the same as what
I'm
we just
messing
read,
with you,
or-
right?
Okay.
There is no spending clause in the
Okay.
Constitution. But the power of Congress to spend money has been derived from the provision he just read. The Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and the general welfare. So there's no specific power for Congress to spend money, but the fact is they can tax. And when Congress gets money through taxes, they have to do something with it, which is spending it. So very early on, a debate arose in Congress between Hamilton and Madison. Right? There were all these debates between Hamilton and Madison. Hamilton almost always won. The question was this: could Congress only spend money on what's enumerated in the Constitution? Or could Congress spend money on whatever they wanted? Madison argued that Congress can only spend money on something pursuant to an enumerated power. They can spend money on regulating commerce, or on establishing postal roads, or doing anything else, raising an army. But they couldn't spend money on other stuff. Hamilton said they can spend money in pursuit of the general welfare. Whatever is in the general welfare, Congress can spend money on. George Washington agreed with Hamilton. And this question lingered for some time until eventually the courts settled on the answer that Hamilton was right. And Congress can spend money on stuff that's not enumerated. Where this comes up today is here. Congress tells the state of South Dakota, hey, those are some nice highways you got there, right? You want some money to fix your highway? Raise your drinking age, 21. Oh, you don't want to raise your drinking age? That's fine. Deal with your potholes, right? It's what's called conditional spending, where the feds offer money on the condition that you do something, right? Now, Congress could not withdraw. Congress could not tell South Dakota, you must change your drinking age. They can't do that. They can't commandeer state legislatures. They can't tell them what sorts of laws to enact. But can Congress do the opposite? Instead of forcing them to change their drinking age, say, okay, we can't make you change your drinking age, but if you guys want some highway money, nice roads, right? South Dakota. Do it. So the question was whether Congress could dangle this string attached to it, right? We all know there is no such thing as a free lunch, especially with government. And when the federal government asks you to do something in exchange for money, there's always something attached to it. There always will be. So let's go into this case. We don't have too much time left. We have enough. Where am I? Yeah, David. So what did Chief Justice Rehnquist say again in South Dakota v. Dole? Could Congress put the strings on these payments?
Yes, we could. Yes, we could.
Okay, tell me why.
They could, because they could put these conditions on it to further an objective that Congress had, even though that was outside of the enumerated.
Exactly. So here again, the court agreed with Hamilton and not Madison. That Congress is not limited to the enumerated powers. They can spend indeed on the general welfare, which is Mark's question. And they can even spend to put conditions on funds for the states to do stuff. Now, the court articulates 4 limits on the spending power, right? There are 4 limits on the spending power. First, the spending must be in pursuit of the general welfare. This is the clause Mark read a minute ago, right? How do we define general welfare? It's basically whatever Congress wants, right? Whatever Congress wants, that's the general welfare. They'll defer to that. The second condition is that it must be unambiguous. What does that mean? When Congress imposes a condition on federal spending, it has to be really clear, right? They have to make clear
what's expected of you and what you get in return. They can't like have, you know, like hidden terms and, you know, mystery clauses. Everything has to be very clear and unambiguous. And this is important. So that way states know what they're getting themselves into when they enter into a federal program. The third requirement, okay, is that to be related to the federal interest. Okay? A condition might be legitimate if it's not related to the federal interest. What does that mean? I have no idea. I think it's the same thing as number one. I've been teaching this now for some time. I can't tell you the difference. The fourth one is, though, the important one. Is there an other constitutional provision at issue? So South Dakota v. Dole is a good example of a clause that most of you never studied but probably all will appreciate, which is the 21st Amendment. Bruin, read me the 21st Amendment.
Mine.
Yeah, I think the Constitution's ready, my friend. I didn't bring mine. I have a DAC of one, right? Keep it always by hand. If you lose one, I have an entire stack in my office I can give you. All right, 21st Amendment, please.
What page is it?
I don't know.
82.
I have an older version. Not older version, different printing. The pagination is different. Read the 21st Amendment, please. This is one of students' favorite amendments, I'm sure.
The 18th article of amendment Constitution, to the Constitution of the United States is hereby repealed. The transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors in violation of the laws thereof is hereby prohibited. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by conventions in the several states as provided.
Okay, that's good. Right. So the 21st Amendment repealed prohibition. Right, it repealed prohibition. But it did a little bit less than that. It said we're repealing the 18th Amendment. Okay? But it said the transportation of liquor, okay, in violation of laws of the states, is hereby prohibited. This meant that states can still prohibit alcohol on their own. This is why you have dry counties, right? So one of the dissents, which is not in your book, actually argued, right? One of the dissents, which is not in your book, actually argued that the 21st Amendment bars the federal government from doing this. The court dismissed that pretty quickly. What you have to remember is perhaps one of the other constraints on the spending power is federalism, right? You'll see this in the Obamacare decision from next week. What if the states are told, accept this federal money or else we'll bankrupt you? We'll take away all of your money. It's like putting a gun to your head and saying your money or your life. Is that actually a choice? So in South Dakota v. Dole, right, in South Dakota v. Dole, the court identified there is some line where federal pressure becomes too strong, where it becomes coercion, and where the conditions on a spending grant go too far. This isn't it. Justice O'Connor, on the other hand, did find that this went too far. Jason, why did O'Connor think this one went too far?
She didn't agree that, she didn't agree with Justice Wickard's opinion that they said, sorry. So his, for the other constitutional provision, what Justice Rehnquist had talked about was the cars on the road and welfare and that. It was interstate, with the concern was people who could be driving interstate and have alcohol. And she felt like that was a stretch.
Okay. Does O'Connor disagree with these four categories here, Jason?
No, she agrees with the 4 categories.
Okay, so Connor doesn't actually disagree with the 4 categories. What she says, though, is that there's not a close enough relationship, right? This is, I guess, number 3, I suppose. That if the government's interest is reducing drunk driving, that merely raising the drinking age is too far attenuated, right? Because what's the argument? Well, if you raise the drinking age, then teenagers may not drink. And if teenagers may not drink, they may not drive. And if they may not drive, the roads will be safer. Okay, then three levels. What O'Connor says is different. She says the mere fact that some teens may not be able to buy alcohol will have almost no effect on drunk driving, right? The majority of drunk drivers are of age. They're over the age of 21. And there's no finding that people under the age of 21, 18-year-olds are a majority. So if Congress wanted to actually tackle this problem, they're doing it in the wrong way, right? They should have done it in a more precise fashion, what we might call more narrowly tailored. Okay? But Jackson, is this the sort of scrutiny that's usually afforded in these sorts of federalism cases?
That they were too narrow?
This sort of strict scrutiny where O'Connor's saying, well, Congress should have done this, something else and not this.
I feel like it happens a lot.
In the hook case,
I'm sorry?
we had a similarity with the hook earlier,
In Lopez, right?
jurisdiction.
So what you have here, though, is O'Connor's previewing the sort of scrutiny that will come in Lopez. Lopez hadn't been decided yet. That we decided, I think, about a decade later. Was it 86 case, I think, 85, 86? But what O'Connor's saying here is, we shouldn't take Congress at face value. We should scrutinize whether, in fact, there's a connection between drunk driving and highway funds. Again, this is not a Commerce Clause case. It's a spending power case, but you see the similarities, right? The same sort of thing saying, let's put Congress to the test, right? Is there actually a connection here? It's okay. Is there actually a connection? And O'Connor says no. For O'Connor, right, the appropriate inquiry, then this is her money quote. For O'Connor, the appropriate inquiry is whether the spending requirement, quote, is a condition on a grant or whether it's a regulation. Is the spending requirement a prohibition? A condition on a grant or regulation? What O'Connor says here is that this is not actually a condition on money. You're regulating the state's drinking age. Let's be honest what you're doing. You're not actually, you don't care about the highway funds. You're throwing some pennies at them and you're trying to get them to change their drinking age. And for O'Connor, this goes too far. Now, O'Connor was in dissent, and I know law students hate studying dissents, but it's important. Because the court would come back to this some years later in the Obamacare decision about the limits of federal power. And the line which was identified in Dole, and O'Connor thought was crossed in Dole, was in fact crossed, according to the court, in the Obamacare litigation. Is that a question?
Oh, no, sorry, I was just thinking.
I didn't hear what you said.
I was just thinking out loud and said I like O'Connor.
Why do you like it?
What do I like? Her opinion?
Yeah.
I think she's fair and she understands that the reason for the enumerated powers in the Constitution is to maintain a certain limit of what one central government can do and still allow states that sovereignty to make decisions that are well for themselves. That we can't use those enumerated powers to do what we want.
Yeah, I think that's a very good. I think it's a very good summary, right? Even though, again, this is not a Commerce Clause case, this sort of reasoning, this skepticism of federal power pervades O'Connor's jurisprudence. Again, she dissented here in Dole, and then she dissented in Raich 15, 20-something years later, right? All right. Let me wrap up a bit and give you guys a bit of a preview for class for class next week. No, we're not doing Obamacare. We're doing next week, right?
No, that's Thursday. That's Thursday.
Thursday, yeah, okay. Thank you. Okay, I have to update my own calendar. So, the Affordable Care Act case represents
the culmination of all of our studies. And it brings everything together in a very cohesive fashion. So first off, let's go back to our little test, right? Are we dealing with a channel, an instrumentality, or an activity? Is this an economic activity? And what the court holds in the Obamacare litigation, by a vote of 5-4, that the decision to forego insurance is not an economic activity. It may be an activity, and it may have a substantial effect in interstate commerce, but it is not by itself an economic activity. Webster's third dictionary be damned. Okay, we go into necessary and proper. Because it's not an economic activity, is it a necessary and proper way for Congress to regulate the interstate health market? We know that if people don't have insurance, they might go to a hospital, might go to an ER, and drive up medical costs. So why can't Congress, as a means, a plainly adapted means of ensuring that costs stay low, mandate that people buy insurance? And here again, the court split 5-4. The court said that even if it's a necessary way of keeping healthcare low, it's not proper, because it intrudes onto the sovereignty of the state and to the sovereignty of the individual to make someone buy health insurance, that it was a necessary but not a proper exercise of federal power. The second part of the Obamacare decision, which you'll shortly read, concerns the spending power. Under the Affordable Care Act, states were given a choice. You can expand the number of people who are on your Medicaid rolls, or we'll take away all of your Medicaid funding. And this was stated very clearly in a letter to the state of Arizona. The court said, this is not a condition, this is a regulation of the states, like O'Connor said. It is, the court said, coercion to require them to engage in this act. Therefore, the court said that the Medicaid expansion was unconstitutional. But then it did something funky. It did something funky. The court said, so states have a choice. They can opt in to the Medicaid expansion if they choose. And Texas, the state, has not opted in. If they want it, they'll take the money. If not, they won't. So in one of the many respects, the Supreme Court rewrote the Affordable Care Act. I didn't mention the Texan power yet. I'll get there later. But they rewrote the Medicaid expansion. That way we now have a situation where some states have it, some don't. If you live in Texarkana, Arkansas, you have Medicaid. If you live in Texas side, you do not. This is a scheme that the framers of the ACA never contemplated, but it's one brought to us by John J. Roberts. Okay. Any questions? No? I will see you on Thursday. Have a wonderful day.